Okay, good morning everyone, and welcome to this session on competition in the digital age, in which we will discuss the impacts of digital transformation on market conditions and how market openness and healthy competition can be fostered so that risks are managed while the benefits of digital transformation are encouraged. Before we begin, may I just remind you that translation, if you need it, is available via the devices in your seat pocket. The questions are very welcome via this room's Bcast address. And just to flag that the Bcast address in this room is different from the other room, it's /OECD CC15. And you can access that via your personal devices. And of course, you are encouraged to tweet away using #GoingDigital. Now, please welcome your moderator for this session, Antonio Gomes, Deputy Director for Enterprise and Financial Affairs here at the OECD.
Well, thank you very much, and good morning, everyone. It's a great pleasure to have you all here, and I'm just destroying things, which is good. It's a good way to start. Today we'll be discussing competition in the digital age. And I wanted to start by telling you that the OECD has done quite a lot of work in this area in the past few years. We've discussed a broad range of topics. That includes big data, algorithms, multi-sided platforms, zero-price markets, personalized pricing, vertical restraints in e-commerce, blockchain and disruptive innovation, et cetera, et cetera. So we've been really quite busy. And today we are very fortunate to have with us a great panel, who I will introduce in just a little while. But before I do so, we're also very lucky to have with us the OECD's Chief Economist, Laurence Boone, that will introduce the topic for us. So, Laurence.
Thank you, Antonio. It's a great pleasure to be here. And it's very exciting because we had a lot of exchanges with Antonio and the competition team to discuss this topic, not least because, and I will mention it later, it's gaining increasing interest with policymakers. Actually, it's very high on the G7 agenda of the French presidency this year. So I think the debate is really moving from academic circle, international organization to take a very high place on the political agenda. But that wasn't at all the beginning of my speech. It was a way of welcoming you and participating here, to welcoming the panelists and all the colleagues that I can see around, including some ambassadors of the OECD. So what I would like to start with is to repeat that it's a topic which is very high on policymakers' agenda. There are special competition working groups in some countries, in the UK, and you will hear from it here, but also in Germany. And as I was saying, the competition authority of the G7 economies are now working on a review and an action plan for review for the French G7 presidency. So these two-day seminars are probably just the beginning of a much longer policy journey. So what is it that makes digital market unique? And how does this shape competitive dynamics in digital sectors? Let me just name 3 factors to start with. First, as you know, there are substantial network effects in platform markets, which means that as the number of users grow, the value of the platforms to users increase. The second, I think, stylus fact is that low variable cost and high fixed cost mean that there are significant economies of scale and scope in digital market. And when you combine that with network effect, it means that a small number of firms may have a very powerful dominant position on markets. And third, data. We know that data from users is playing an increasingly important role, both as an input and a competitive asset. And consumers exchange their data to access services at a price of 0 and without necessarily critically examining the terms of the deal they get when they do that from firms. So all these have an impact on fair competition. Well, let me first say that there are elements that suggest it may, and research, including by the OECD, points towards concentration of firms and other outcomes that are usually the results of anti-competitive behavior. And this is usually research that we do across department between DAF, STI, ECO, and many other people, so as to have the most comprehensive view. So first, markup charged by firms are increasing. And that could be an indicator that market power is growing, and therefore that competitive intensity is weaker than it used to be. Second, we're observing that fewer startups are emerging, particularly in the digital sector. And that suggests that large established firms may face reduced challenges for their incumbent position. Third, there has been an acceleration of merger and acquisition activity that focuses on digital firms. And while competition authorities have closely reviewed many large tech mergers in recent years, and you know them, Facebook, WhatsApp, Google DoubleClick, or Microsoft LinkedIn, the same authority, there are countless small acquisitions that fall actually under the radar screen of competition authorities. Fourth, there are really signs that the largest firms are earning an increasing share of revenue. And our revenue concentration is not necessarily a meaningful indicator on its own, but in combination with this other trend, it may suggest that something is changing about competitive dynamics more generally. So having listed these 4 points, should we be concerned? Well, there are several possible reasons why we should be concerned. First, regulation may be limiting the ability of firms to enter market to challenge market power. For example, when regulation is too heavy, and this is something that you've seen in many sectors, including the financial sector, then it protects the large incumbent to the detriment of young, smaller firms for which heavy regulation imposes too much cost. Second, anti-competitive conduct may be at play. Some firms may be abusing their dominant position to keep competitors out of a market. For example, when they impose exclusivity or pricing parity terms on their consumers. Third, some large firms may have acquired startups, and I was mentioning that before the startups become large enough to trigger a review by the competition agencies. And then some markets may feature entry barriers that are impossible for new entrants to overcome. So they may resemble natural monopolies or oligopolies. Having said that, and I think this is something that we've paid very special and cautious attention here, even if we have indication that competition among firms is weakening, that does not necessarily mean that there has been misconduct on the part of any firms. Market power is and could be the legitimate reward for innovation, and an increase in market power only reflects the greater impact that technological innovation is having on markets. So I think that's what the panelists, if there's one thing they will agree on, is that we need more work on all these issues. We can improve the existing competition tools, but it also may be the case that we need to enrich the competition policy toolkit to address the new competition challenges which are created by digitalization. So if you allow me, let me offer a few directions for the debate which is going to take place and which I'm sure will be very lively and informative for you all. First, I will just make 3 points, don't worry, I won't be too long. First, there are 3 opportunities, there are opportunities, we think, to improve existing competition laws. Agencies may need to look deeper at the prospect of mergers, leading to a loss of potential competition. They could also reassess mergers ex post a few years down the road, because competition issues may have arisen on the journey of the merger. For mergers as well, authorities could decide that the magnitude of potential harm to consumers, as well as the risk of harm occurring, is relevant to decision making on merger cases. Authorities may also need additional tools to analyze and detect novel forms of firms' misconduct, such as algorithmic collusion, and I think Antonio has a lot of questions about this. And I think it will surprise nobody in this room to hear that we also would like to support a deepening of international cooperation for understanding possible misconduct and addressing it when it takes place across borders. And as I was saying, this place is also the forum of a competition authorities working group looking at these issues. Second, we need to consider whether the current legislative framework is itself contributing to problems regarding digital competition. And here I'm particularly thinking about the way that the OECD is upgrading its competition assessment toolkit with a view of helping policymakers to identify regulatory barriers to competition in digital sectors. And third, and this will be nearly my last point, new policy solution may be needed to protect and promote competition in digital markets. I will just quote 3 examples. One, there may be a need for measure to promote digital competition through, for example, data portability measures. We may also need to find a way to enable tech firms to compete by paying consumers for their data, and I'm sure this will be the object of a debate. But this could enable consumers to share in huge profits that are being made by selling this data to advertisers that use them to target consumers, and firms that use them to train and apply pricing algorithms. Also, I'm sure something which will be the object of fierce debate between the panelists. And finally, consumer and data protection regulators can also address growing consumer concerns about digital firms and at the same time promote digital competition. Just one number here, 15% of EU citizens say they don't use online banking services or shopping because they're afraid of security and of threat to their privacy. So that's a bone that you may wish to look at. So there are many indicators causing concern about the state of markets and competition. There's likely no single cause. I think it's work in progress. The fact that you're on this UK working group is a signal that the G7 is addressing this issue is also one. And I think it's, as I was saying, a really exciting path for competition, and I wish you an excellent debate this morning, and hand over to Antonio. Thank you.
Thank you very much, Laurence. I think that you've given us a lot of food for thought and a lot of questions, but also quite a few answers already. So I think that will be useful for our debate. It was also interesting to see how these competition issues in the digital age are now permeating into the political debate and are influencing, for example, the discussions at the G7 level. I think that that's very welcome as well. So today, as I mentioned, we have an excellent panel of speakers. Let me introduce our members of the panel. So to my right, I have Amelia Fletcher. She's a professor of competition policy and deputy director of the Center for Competition Policy in Norwich, non-executive director at the UK's Competition and Markets Authority, and of particular relevance today, a member of the UK government's independent expert panel looking at competition in the digital economy. Here next to me is Geoffrey Manne, is the president and founder of the International Center for Law and Economics, a non-profit, non-partisan research center based in Portland, Oregon. Jeff is an expert in the economic analysis of law. He has testified on several occasions before Congress and at the FCC and FTC, and he regularly files written comments and amicus briefs on key antitrust, IP, and telecommunications issues. Next to me on my left, we have Cristina Caffara. She needs no introduction, but she's the head of the CRA's European competition practice. She has directed the analysis on several of the high-profile cases of the last 20 years before the European Commission, including matters involving Google, Microsoft. She also worked on mergers, for example, with merger cases relating to Uber in Singapore, etc., etc. It's a pleasure to have you here. And to my further left, we have Cecilio Madero. He has been the Deputy Director General in DG Comp at the European Commission for Antitrust and Cartels, but now is also, he's just been appointed Deputy Director General for Mergers. And as you probably know, I would say that it's an understatement to say that digital markets have been keeping you busy for the last few years, you and the Commission. So I would like to begin by asking our members of the panel to say some introductory remarks, and then we'll follow on to a debate. We will have some minutes at the end for questions from the audience. So I do ask you to submit your questions digitally by Bcast, and then we'll run them through as many as we can at the end. So Amelia, can you kick off the debate? Thank you.
Thank you. So, as you've already been told, I'm a member of this academic panel that's been asked by the UK Treasury to report on their views on competition in the digital economy, and we will be reporting very soon. And I would encourage you to read our report, of course. But I should emphasize that I'm speaking here very much in my personal capacity, not as a representative of that panel. I think there's a few questions that I want to try and at least give initial answers to. The first is, can we make use of our existing competition toolkit better in digital markets? And I think there are three key areas where the answer is yes. The first is I think there's been a failure by agencies to date to really understand the likely evolution of digital markets, and in particular the role that big data, AI and network effects can play in that evolution. And I think that's evidenced by certain mergers where they were pretty much just waved through, even if they were looked at. But actually with hindsight, you look at them and go, you're not as sure that they were good mergers, and certainly that they should have had a lot more investigation at the time had the authorities had better understanding of likely evolution. I think in that space, enhanced agency experience will be valuable, but also getting the right expertise into agencies will be really, really important. Another area is that agencies have been over-focused on analysing kind of short-run effects, and particularly price. And I think the reason for that is we kind of know how to do it. We've got lots of the right economic tools. So it's that classic lamppost thing where you look where the light is, but not where the problem is. In fact, we should be looking at the long-run impact on consumer welfare in these markets. That's already the test, but we don't necessarily do it enough. So authorities really need to develop their economic toolkit to assess these long-run effects more effectively. And the third is I think there's been a very strong kind of reliance on the process of what's called Schumpeterian creative destruction. So that the idea that these big digital platforms will very, very quickly lose their market position if they fail to innovate and deliver consumer benefits, because it's a very dynamic and contestable market. I think that has led to a generally pretty non-interventionist stance in these markets, although there are obviously notable exceptions. I think it's not really supported by evidence by this point, and I think our priors on this do need updating. So that's better use of our existing toolkit. The question then is whether our toolkit needs some at least minor adjustments. And I think one of the key concerns in these markets is that major platforms have a habit, we heard from Laurence, that they have a habit of buying up or foreclosing their main potential rivals. So you get, and this elimination of potential competition can be very harmful indeed for long-run consumer welfare. But at the time you're looking at a merger or a piece of exclusionary behaviour, it's far from easy to demonstrate clearly that the often really quite small targets involved are really going to grow into major rivals. And this level of uncertainty doesn't fit well with the current balance of probabilities standard that we typically have across competition law for intervention in many jurisdictions. So if you think about mergers, this means that agencies may be unable to block mergers even where they very clearly give rise to a very negative expected value in kind of economic terms, but where the very, very serious potential harm perhaps has a likelihood of a little below 50%, not above 50%. So there's no weighing up of likelihood and harm in the way that an economist would do in assessing expected value of something. This issue could usefully, I think, be revisited to ensure that these serious but lower likelihood harms are given their due weight in the merger control process. For abuse of dominance or monopolization, speed of intervention is a really significant problem, with digital cases often taking kind of 5 to 7 years. Interim measures are used rarely, if ever, to protect competition in the meantime. This suggests that we really do need to make it quicker and easier to bring these abuse cases, to get our theories of harm more up to date with the sorts of issues that we're observing, and also to get better at imposing interim measures. So the third question is, even if we take our existing rules and we adjust them, is that going to be enough? And I think there's at least an argument to be made that the law on abuse of dominance or monopolization is insufficient as a way of providing a clear framework for competition in digital markets. Abuse cases take a really long time. They tie up huge resources. The resulting remedies tend to be narrow and backward-looking, and the peculiarities of the few cases that authorities actually manage to take mean they don't necessarily set clear rules for wider deterrence. So I think there is an argument for a more proactive and upfront, but still very pro-competition approach to these markets. So some form of specialist regulatory body working in participation with stakeholders to set really clear rules for the game, with the aim of ensuring that competition works effectively in the first place, rather than not setting rules, bringing cases many years down the line, imposing massive fines, but not really solving the problems for rivals and enhancing competition. Finally, how can OECD help? There's two very obvious ways. One is actually in mergers, as Laurence said. There's a particular issue that many of the major digital acquisitions have fallen outside notification thresholds in many jurisdictions due to the low turnover of the acquired party. As such, several potentially anti-competitive mergers have gone largely unreviewed globally. And I think OECD could very usefully encourage its members to find ways of bringing these sorts of mergers into jurisdictions so they can at least be examined. More crucially, I think if there is going to be a move towards greater use of upfront regulatory pro-competition tools, which go beyond existing competition law, then this would be very usefully done on a coordinated international basis so that the major global digital platforms face broadly consistent and sensible rules across their worldwide business. Thank you.
Thank you very much, Amelia. Jeff?
Thank you, Antonio, and thanks to everyone for having me here. I'm going to kick off a little bit of debate already, and preface my remarks by suggesting a little what appears to be a bit of a disconnect in some of your remarks, Amelia, that that both we need more information and we don't really understand exactly what's going on, and also that we are in a position to impose interim restraints or interim remedies or ex-ante regulations, some other things suggested that we have more knowledge than I think maybe we do. And I think that's in some ways the core of my remarks, is the lack of information we have coupled with an urge to do something, and that strikes me as a really problematic coincidence of effects, of characteristics. So there's a lot of attention at this event, including on panels yesterday, on the economic and social harms of digitization, which I think is perfectly appropriate. The question is really how best to address them, given what we know. And for many people, the answer is, in fact, competition policy and antitrust to address dominance specifically. Far too often, though, the offering of solutions seems to precede adequately identifying the problems. In the US, for example, just recently, Senator and presidential hopeful Elizabeth Warren recently proposed a plan to break up large internet platforms because, and I quote now, "Today's big tech companies have too much power over our economy, our society, and our democracy." Big is bad, in other words. The chief economist of the EU Competition Authority, Tommaso Valletti, tweeted his agreement with Senator Warren's approach, and Margaret Vestager was more circumspect in her response. I think it's worth noting. But it seems to me that there is a rush, clearly on display in Warren's proposal, but arguably also in DG Comp's actions against Google, for example, to equate harm to specific companies with harm to competition. In the complex digital arena, this is decidedly troubling. So, for example, over and over, I see claims that Amazon impedes entry and innovation on the basis of unsupported assumptions and anecdotes about how some merchants feel mistreated. But does anyone seriously think that on net, Amazon hasn't dramatically increased the ability for manufacturers and small merchants to reduce costs and reach larger markets? When Facebook copies features from Snapchat to improve its service, a cry goes up that it is appropriating Snapchat's features to impede its ability to compete with Facebook. And there the analysis often stops. But unspoken is the reality that when Facebook improves its services, it directly benefits some 3 billion users and a plethora of firms accessing users through its platform. Absent IP infringement, which isn't alleged here, this must be weighed against any speculative possibility that if only Facebook didn't mimic Snapchat, Snapchat would impose powerful competitive constraints on Facebook. In discussions about difficulties navigating the digital environment for small firms and consumers and disadvantaged members of society, it's too often minimized or missed that platforms and other companies that operate at scale are key parts of extending the benefits of the digital economy to those it might otherwise bypass. That means, indeed, that some smaller, less effective firms may struggle, but it also means that the benefits of scale, power in Senator Warren's pejorative phrasing, can be massive and harder to see and measure than the disruption of a few competitors or theoretical competitors. Competition is certainly important, but competition in the digital age looks different than the blackboard models of atomistic competition from Econ 101. Most of what economists and enforcers understand of the effects of digital platforms is based on possibility theorems that are often poorly informed by market realities and evidence. The rush to do something, especially to address non-economic problems with competition policy, seriously risks doing more harm than good. And none of this is to say that these firms can't undertake specific actions that might have anti-competitive effect, or that they should get a free pass from enforcers. But incomplete theorizing and scant evidence are insufficient to understand the complexities of managing a digital platform. So Senator Warren's proposal asserts that breaking up big tech would remove the bad without destroying the good. I would argue that what we know of the Commission's Google Android action seems to suggest a similar understanding. But the likelihood of this outcome is vanishingly small. We need a much better understanding before we go too far down the path of aggrandizing political power in the name of thwarting economic power, not least because it is far from clear that regulators are able to design markets in ways that will do more good than harm. Thank you.
Thank you very much, Jeff. Cristina?
Okay. Okay, I'll try and put the absolutely diametrically opposed case to Jeff. You're shocked to hear it. So, Jeff, I think you obviously put forward a position which is very much what we hear when we talk to Americans, and I'd like to just take that up initially, that we in Europe care about protecting competitors, and that somehow we are very unclear about all of this, and there is a rush to do something which is very ill thought through. You know, you mentioned I was involved for my sins all those years ago in the Microsoft case. I was, in fact, on the side of those opposing Microsoft, Cecilio remembers. And at the time, the big narrative that was around that case on the part of Microsoft and its supporters was, if you dare intervene, you're going to absolutely undermine a very delicate ecosystem. We are going to stop innovating. You're going to appropriate our innovation. Now, what has actually happened? That is an intervention that was on point, it was appropriate, and as I heard recently said, it created the runway that launched Google. So I think that it is, to my mind, important, in fact, to power up antitrust enforcement, not to just take a step back and nap around it. This is an expression that is very popular these days when people on the Twitter feed sort of keep talking about the agencies napping in the US for the last 20 years after Microsoft. Certainly not what we've been doing in Europe. I think when you think about the various initiatives that are, and the various activities that are in place here, there is quite a lot going on. The Commission, of course, has enforced a number of cases against Google. There is a study group which is going to report reasonably soon on digital. The UK is tracking. There is the CMA having just issued a reform package. There is the House of Lords, the peers saying we need to do this, and we are hearing, of course, a lot about Amelia. France is putting forward interim measures. Germany is doing stuff. So I kind of feel that this is an important point. We're at an inflection point. We need to think very carefully, yes, about what we do, but it doesn't mean that we need to step back and think about it for another 20 years without taking action because we don't really understand. I think actually, while it is not the case that we understand everything to perfection, we do understand much more than what some say we do. I think there are some things that are quite clear, I think, as economists. I think the notion, for example, let me give you a few examples. The notion that the fact that price is zero means that markets are competitive is completely misplaced. A price of zero can well contain a markup. Price is on a line. The real price might be, the competitive price might be negative, and there is a markup that takes you to zero. Who is to say that the price of zero is saying markets are competitive? And when you have a price capped at zero, you have immediately the sort of one monopoly profit theorem, which is used to say that firms have no incentives to foreclose, failing completely. You fail. So then you have demonstrably, in many cases, incentives to engage in activities that may foreclose. You have, we heard earlier, multi-sided markets in which there are contracting externalities, in which one side may not internalize the effects of foreclosing the other side, and that's typical of this. We have network externalities, which means that we can raise rivals' costs easily. If you are an allocator of traffic, you deprive someone of traffic, you raise their costs directly in a way that is not possible in other industries. So we know quite a lot about the economics of this market. We understand it. And frankly, let's take a step back. Let's not just say, oh, we should be careful in case these markets might in future, maybe with the wind behind, tip. Some of these markets have tipped. They tipped into monopoly, internet search, networking. These markets have become quasi-monopolist. And this idea that we could rely on a notion of multi-homing, leapfrogging, jumping in and out of other firms to overtake the monopolies, that the monopolies was only temporary, has clearly not worked because we don't see this overtaking. Whenever you talk to someone in Google, the only example that they can give you about anyone overtaking anybody is MySpace 2003, and this is 15 years ago. So, you know, we need better examples if that is a dynamic which is at play. And, you know, the notion that you have increasing output is a good thing, but it isn't a normal industry in which more output means better. This is an industry in which more clicks may mean addiction, may mean things that are not, as a society, things we actually want to see. So I think that this is an area in which I think we know a bit more than you, Jeff, say we do. It isn't to say that we need to rush headlong into doing something which is equivalent to breaking firms up. I do happen to agree that Warren's proposal seems disproportionate to me and obviously politically motivated. I'm not qualified to comment on American politics, but I would line up with Commissioner Vestager saying this seems a bit extreme. And I think also Tommaso, he likes to stir, but absolutely doesn't think that this is what we should be charging into doing. Concluding, is there areas where we need to do more? Absolutely. And as economists, I think there are areas in which we need to sharpen up and be more directive in terms of the things we do. So one area which I think is super important is developing coherent theories about exploitation. As economists, we always kind of think about time, bundling, foreclosure, exclusion. This is the kind of bread and butter. But it isn't only that. It isn't only a Microsoft type of theory, which we sort of seem, you know, I have a Microsoft hammer, I'm looking for a nail. No, there is in this industry a great potential for exploitation on the part of firms with great market power who can extract very unfavorable bargains from the other side, from consumers with the data that we provide, to advertisers, to companies, to other counterparties. So agencies are a bit behind in exploitation in terms of accepting exploitation as a form of abuse, but we absolutely need to push that as one of the areas where I think there is work to be done. The second area is certainly mergers. Amelia mentioned it. I think that this is an area in which we need to develop significant screens, because of course we can't just say anyone big buying somebody bad is going to be blocked. I mean, what exactly are the telltale signs that we are going to be looking at? And I can mention a few that I think are coherent and economists can work on. And finally, the last point is really the one about solutions and remedies. It is true that the weakness of antitrust is that the remedies are terrible. You just give a fine to a company and then say, bad dog, don't do it again, and they do it another way. So what is the answer? The answer has got to be, let's kind of sit and identify collectively what the problems is and try, under the supervision, oversight, and frankly sticking carrot of an agency, some sort of solution. The example that we can talk about it later is digital advertising. Nobody has in that area the faintest idea about that black box. Getting various sides to the industry, sitting around and explaining it under the oversight of an authority may be a way to get progress done rather than a long infringement case. I'll stop here.
Thank you very much. Cecilio?
Yeah, good morning. Well, first of all, although I am so-called senior official from the European Commission, and in particular from DG Competition, I do not pretend to represent today the official position of my institution. This is the type of caveat that you can expect from an official. I also hope that the fact that I've been placed on the far left of the table does not mean anything in particular. Must be, yeah. I'm not complaining, you know that. I must say, but this is going to be a very interactive panel, I have the feeling. Among other reasons, because as Cristina said, I heard very similar speeches like the one that Jeff has just addressed to you in the early 2000s when we were dealing with Microsoft. And I have the feeling, but I'm very conflicted because I was the case manager of this case, that we were right. And by the way, I'm getting worried when I hear economists, honorable economists like Cristina, Caffara, and others saying, you were right, because... no, more seriously, I have been particularly interested by the opening remarks of Laurence, and I would like to come back to it to some extent from a different angle, because it is true, and this panel today is a very good example of the widespread policy debate on the various issues presented by the digital economy, and in particular by platforms. I think that we discuss a lot, and today is a good example of what are the repercussions of online platforms on the market. And we probably forget a bit that there is also a big and probably not necessarily positive, depending on how we manage platforms, influence on our democratic societies generally considered. It's about market power, which could be used in a way which might affect our civil society and our democratic societies, as I said before. There are questions about the accumulation of large volumes of personal and other data by the largest digital players, and whether the use of this data can undermine both the ability of a smaller company to compete with the big ones. And my answer to this personal answer is yes, this risk is there, and we should not try to forget it. But also, what is the effect of this platform vis-à-vis, as I said before, key founding principles of our societies, including freedom of expression and free and fair elections. Well, I mean, we are not going to talk about fake news and what is happening on specific elections and the influence that this platform might have. Certainly, competition rules cannot solve all problems, but we believe that we can, antitrust enforcers, we can play a significant role, a significant part of it. Cristina has referred also, Amelia, to the novel characteristics of these markets, and Laurence also has referred to network effects, zero-price markets, economies of scale and scope. But I would add also, as well as data and its accumulation as a parameter of competition, because we are able to use data from a competition perspective. I will try to say how in a minute. The sector is complex and fast-moving. We all know that. We pretend, but I try to be discreet and at the same time not over-optimistic that the European Commission has sufficiently, I wouldn't say demonstrated, but we believe that we have taken actions in a number of cases in recent years with the aim, whether we have managed or not is another matter, to preserve competition in this sector. In antitrust, by the way, it was mentioned that until now, well, for the time being, I'm still running antitrust and cartels, but as from the 1st of March, I'm the new DG responsible in DG for mergers. But in antitrust, we have looked at practices including self-preferencing. I'm referring to Google Shopping and the decision that we adopted in 2017. Pre-installation and contractual restrictions, Google Android, the decision that we adopted last year. Cristina is right, again, in saying that it's not about money. There are companies who can pay n'importe quoi, using French, we're in France. It's not about money, it's about, well, certainly fines can be a good deterrent for companies not to engage in similar practices, but what it counts is the type of behavioral or non-behavioral remedies that you are able to impose and to enforce. And believe me, and I'm talking on behalf of my commissioner for once, Mrs. Vestager is not someone who is going to drop any ongoing enforcement of one of our decisions without coming to the conclusion that the remedies are effective and put an end to the abuses that we have declared. Of course, abuses which have to be in fine confirmed by the European courts in Luxembourg. So Google Shopping in 2017, Google Android in 2018. We dealt with e-books cases, and in particular Amazon in 2012 and 2013. MFN clauses, again, Amazon in the famous e-book case in 2017. Exclusive rebates after the Intel ruling from the Court of Justice mandating back to the General Court our decision on Intel. We have, for the first time in 2018, adopted another decision, this time fining heavily Qualcomm. We have been dealing with standard essential patents, which are key for this type of debate, and we adopted decisions, either prohibition decisions or commitment decisions in 2014 with Motorola and Samsung. And in the area of merger control, we have conducted detailed investigations in cases such as Microsoft LinkedIn, Apple Shazam, and Facebook WhatsApp. I would like to say that these cases show, at least from our perspective, that competition assessment crucially depends on a fact-based, not just imaginative, speculative scenarios, fact-based, evidence-driven, case-by-case approach. I hear Amelia saying, rightly, although I might have some nuances, we need quicker and more proactive and upfront enforcement of our competition rules. I have some reputation in this respect, and still, today I might appear in front of you conservative without being conservative. But I guess that we all agree that this proactive, upfront, quicker enforcement has to stand. First of all, court control. If you don't manage to convince the judges, unfortunately we live in a rule of law democratic society where the last word is for judges, in particular General Court and the Court of Justice in Luxembourg, in the case of the European Commission. If you don't manage to go through this judiciary control, you are nowhere. And last but not least, you are supposed also to respect the rights of defense of the parties that are subject to your court scrutiny. So I do not pretend that the solution to the current challenges posed by this new fast-moving market, and in particular online platforms, is only and exclusively antitrust enforcement. I think that we have to go for what I would call, and my commissioner has mentioned, as a sort of mixed approach or cocktail of enforcement when appropriate and regulation when needed. And the two instruments, the two tools are not contradictory, but they should complete each other, because it is obvious that with an antitrust enforcement, with the competition rules, you go on a case-by-case basis. You can create a precedent which can be applicable to similar situations, but the market power of some of these big guys is such that you need to regulate the animal. I'm not calling animal anyone in particular, but you need to regulate this phenomena, because otherwise you might be always late when you need to fix problems which are already affecting, as I said, smaller players, but also our societies. I conclude these opening remarks by referring to, and I hope not to appear too conservative today, by saying the following, which is, before we go, my commissioner has recently said, and I would only repeat what she said, Margrethe Vestager, of course that we are not against the possibility of fine-tuning, better nuance, or better adapt competition rules, and in particular the competition rules for the treaty and the derivative law which follows in case of need. But let's make sure that we know first what are the problems that these competition rules might trigger, and I don't think that there are so many, before we go for a reshuffle that might be counterproductive. And let's make sure that we exploit the possibilities which are already offered by the current existing applicable rules. I give you one example. There is a so-called rule which might serve us in new ways to look at whether massive concentration of data in the hands of dominant companies, I'm not referring to any company in particular, you put names to them, might approximate what we have called in our legal but also economic jargon, essential facilities, to which access to this massive amount of data, under certain conditions, should be granted to competitors. What I'm saying, and with this I close provisionally my remarks, is that we might be soon seen, or we might be faced with cases where the massive concentration of data might trigger cases using existing antitrust rules. Thanks.
Well, time really flies, and it's very difficult to keep the panelists to actually a few brief minutes in their initial remarks. I think that one of the several questions popped up, and I think that the speakers would like to react to what each one has said. But I also have to think of BCAST and the questions that we have from the audience. And one thing that was discussed is okay. So Jeff, you mentioned that there's all this discussion about if big is bad, whether we should do. That there have been calls to break up the big tech companies. And I'll just ask very briefly on the panelists, because there was this question: don't we need systematic measures against data monopolies that go beyond case-based competition law? And Cecilio has just mentioned that we should do more, well, we should keep to case-by-case analysis. Of course, there can be a mixed, but just a very, very quick, and I really ask you to be all very quick. Jeff has already talked about this, so I would start with Amelia.
Okay, so in terms of just wanting to go against firms because they're big, I think, big firms can have political power. I don't think it's for antitrust to get involved in that. I think there are very important checks and balances to have around political power to deal with those sorts of issues. I think antitrust is about economic power, but I think that some of the digital platforms that Elizabeth Warren talks about do have a lot of economic power. I also, like the Commissioner, a European Commissioner, feel that we are not in a position yet where there is the evidence that they need to be broken up, because actually I think there is lots of potential for using other tools to ensure that businesses and consumers using those platforms get a fair deal and that everything works in a very pro-competitive way. And I think there are some very significant risks to the economics of those platforms if they were broken up. So I do think it would be a very dangerous and unjustified at the moment approach. But I do think that the fact that thinking has even got to that stage does show that there's a growing consensus that there is an issue and that we do need to think of routes to deal with it. And I very much feel that there is an argument for not just relying on the antitrust cases, but doing something wider and more prospective. I think within that, one can try and work, one can try and set rules that kind of align with antitrust cases, but one can actually go beyond that. Some of what Laurence was talking about at the start, some of the reasons why markets have tipped are not down to any bad behavior by the platforms. They had no strategic behavior, but rather the lack of multi-homing, the lack of interoperability, the lack of data ownership and data openness. And actually, having more upfront regulatory thinking in these markets at the point where some of these things are being designed could be incredibly valuable for setting the framework for competition. And I think in this space, data portability, which the EU introduced through GDPR, but it's not set up to really generate competition yet, but increased data portability with greater rules around open standards and things like that could really start to generate more competition. And that is another pro-competitive tool that I think we could do more with.
Thank you. Jeff, very quickly.
Yes. So
Really quickly.
I will. I think it's important to point out that, in my experience, small firms also have a lot of political power, especially groups of small firms, and I'm absolutely not certain that it's clear that there's a direct line between the size of a firm or its economic power and its political power. With respect to data monopolies, I do think that there's a lot more we need to understand here, and there seems to be a rush to assume that data has a particular place. Well, first of all, there's a rush to assume that data is something almost monolithic and easily definable. There are actually a lot more complications around it, and the competitive effects of mandating portability or doing other even more invasive things with to limit data monopolies, I don't think is really well understood. And finally, I would just point to, for example, the Australian Competition Commission, which recently issued a report on the role of a couple of big platforms and with respect to sort of aspects of our democracy and the like. And it shouldn't escape notice, but I think it has a lot, that one of its core proposals in this study, which largely deals with news, is essentially the imposition of a censorship board at the government level to determine whether news seen in people's news feeds sort of meets some government-imposed standard. This isn't to say that all government interventions are of that nature, but it's important to be wary of that kind of approach.
Cristina, could I also add something on killer acquisitions? We've just heard recently Tommaso Valletti saying that we should change the burden of proof when we're dealing with mergers by certain large companies. Can you also react to that? What's your...
Well, briefly, I think the area of acquisition of small companies is an area of enormous importance because this is an area in which competition in these type of markets is competition for the market. It's competition to actually acquire ultimately a significant role in a market, not a small market share. And once you think about the potential welfare loss that is associated with ultimately undermining a future innovator, a future challenge to the platform, that welfare loss is huge, which is why I think we really need to take this super seriously and we really need to look into that. Now, the first issue is to capture these kind of mergers. Much of the problem is that they are under a threshold. So there is a question of where do we place the threshold? How do we do it? We look at value. Certainly we need to. Do we actually introduce rule that says whenever a super dominant company acquires a small company, however small, they need to come in and be reviewed? Possible. Then there is the question of what standard do we apply? Do we actually change the standard that we apply in, and Amelia referred to it, in some of these cases, in the normal cases? In other words, do we modify the balance of probability that we need to have in order to intervene? Or, as you say, some are also of the view, Tommaso has expressed views in this, Fiona Scott-Morton has also expressed it, that one could even think about shifting the burden of proof entirely. In other words, saying, well, given the asymmetry of information that exists between regulators who are examining these acquisitions and the companies themselves, then we presume potentially that they're bad unless you convince us that the efficiencies are significant enough to overturn that presumption. I'm not saying that this is the perfect solution, but this is exactly what the debate is and needs to be had.
Thanks. Cecilio, I would ask you actually two questions, and I'll take the opportunity to ask one from BCAST. And the first one is, we talked about being quicker in the analysis. We know that sometimes antitrust enforcement is really not keeping up with the pace of the fast-moving pace of digital markets. What can we do to actually improve this scenario? Do we need more tools? Do we need more resources? Can we use more interim measures? And my second question, and it's from BCAST, is, should we not use competition policy and competition law to enhance Europe's competitiveness? I think that this is a bit more, this is trickier.
Should I say thanks for the questions? Yes, I guess. Well, certainly we need to improve speed and delivery, because it is obvious that these are very fast-moving markets, and the last thing that you could do or you should do is to go with remedies when the company that you want, when I say the company competitor that you want to protect, it's not because we want to protect competitors, it's because we want to protect open markets, contestable markets where there is choice and, if possible, low prices for European citizens. So this idea that I hear from time to time in the US, that the Commission cares about competitors, not about competition, is slightly simplistic. So we have to be quick, we have to be fast, and certainly resources is something that we are always in demand in DG competition. But I would like to draw your attention to the fact that when the Commissioner, Mrs. Vestager, decided to, or instructed us to go and prove the Android case, it took us, for a while, we were trying to settle the case. When she decided to go for, when she took office, to go for a more confrontational, if I may say, approach, it took relatively little time to come to a conclusion that on Android, Google had to do what we have now imposed in the meantime, last year. The same goes for shopping. Shopping is something. So what I pretend, I'm not going to give you a list, is that I believe, I want to be humble, that if in the near future we are faced with cases where the reaction has to be quick, I pretend that the Commission, and in particular DG Competition, will be able to respond to these expectations. And on this respect, I would like to say that this idea that in these fast-moving markets represented by online platforms and this ICT new disruptive revolution, this idea that you don't need to care, you enforcers, because innovation is so fast that a monopolist is going to be replaced by someone else later on, because as Cristina said, these companies are fighting for the whole market, not only for one part of it. Well, this is not, with due respect to those who believe the opposite, I don't think that this is the case. One of these monopolists in these new fast-moving markets, once they have monopoly power, it's very difficult to move them from this situation because these are very entrenched dominant positions. And that's why I believe that the answer to this type of situation is a strong enforcement, and I believe that the Commission will be able to deliver, and also regulation, because as I said before, you cannot expect doing everything with competition rules, regulation, but it has to be at the same time, it's a pity we don't have more time for it, regulation which should be as much as possible proportionate and smart, because you don't want to kill innovation. This is something that we all share in this room. We have to avoid market power, market abuse, not market power, market abuse. We have to preserve at the same time innovation and the possibility for those who innovate to detract from the market the type of benefit that they are entitled to get. Concerning whether we should or not use our competition rules in order to originate European champions, from that time my question is, I'm asking myself, are we talking about European champions or national champions that we would put at European level in order to make this more palatable? Well, look, I think that the answer...
Very quickly.
Sorry?
Really one...
Well, so the answer is...
2 seconds.
The answer is, as Commissioner Vestager said, we need to make sure that, I mean, we are open to discuss about possible adjustments of our competition rules, but not to the point of putting at risk fairness and the competitive assessment, which has to be based on merits, on the evidence brought to our attention, and on the preservation of open market without industrial policy consideration that should be obtained through other tools like probably a decent control of foreign direct investment or a better use of trade instruments. Thanks.
Thank you very much, Cecilio. And certainly, if we promote competition, we'll promote innovation. If we promote innovation, we'll certainly promote competitiveness. So we'll see how it goes. It was a great panel. It's really a shame that we were really warming up and we would now start really having a serious and intense debate, even more than we had so far. I would like to thank all my panelists. You've done an excellent job, so please join me in thanking them.